Morning, today September 23rd. Welcome to Lawrence County Municipal Court. I'm Judge Capper. We've got a pretty big docket today. As you can see, there's a lot of people here. Be patient, we'll get to the case. People that have reviews need to be in the courtroom now. Your name's called, come up to the table to your right, and I'm going to review your file with you.
Jeremy Butcher, Misty Dotson, Stephen Littlejohn, Crystal McMillan, Allie Caitlin Hankins, Micah Mayo, Taylor Carpenter, Ben Smith.
Jeremy Butcher, I'm going to pass. I have it as my file is set for the 27th rather than today, so it should be on the docket for Friday. Misty Dotson,
Yes.
3706 is your.
Sorry.
Some reports from Marshall Health, which are good. That finished your community service. You just have to also pay off your fine. So, do you have a payment you're making today?
Yes.
How much are you going to pay?
20.
Okay. Make your payment. You can also work some of your community service, and we've got a date coming up the 5th and the 12th.
5th and the 12th?
5th and 12th of October, we're going to be we'll give double credit. So if you work you've already done your community service, so you'll get $100
Yes.
off your fine.
Okay.
If you work one of those days, so you'll get a $100 credit toward your fine.
Okay.
You work either the 5th or the 12th, and you've got, you can do both of them. That would knock $200 off your fines. One's Windsor Township Cleanup Day and the other's Union Township Cleanup Day. So I will we'll go into November for your next review. Do you prefer Mondays?
Yes.
Okay, November the 4th.
November 4th.
Will be your next review. Once you get your fines paid and get a little further along with your counseling, we'll be finished.
Okay, is that for 9 a.m.?
9 a.m. on November 4th, yes.
All right, thank you, sir.
You're welcome. Stephen Littlejohn. He's the IRS.
Yes, sir.
He's doing very well, making good progress.
Okay, that's good. And he's been making payments on his fines. Do you have a payment today?
Yes, sir, I do.
How much?
50.
Okay. October the 28th is your next time.
Okay.
9 o'clock, October 28th. See the clerk to make the payment.
Thank you, sir.
Thank you.
Crystal McMillan, 16,688. And she actually has a bond up. She should have been on the sentencing docket. So I'm going to put it aside and we'll deal with it at the end of the court. And a lot of times she shows up late. So I'll put her aside. And if she doesn't appear, we'll have to set a bond forfeiture hearing. Ollie Hankins, 2438. I don't see that you've done anything since you got sentenced. Have you done anything on your case?
No, honestly, after the case, my husband got diagnosed with stage 3 melanoma and had to go to UK and have surgery on his back, his neck, and under his arm for the lymph nodes. And we were there like all summer, and with me being a stay-at-home mom, like childcare. But I heard you say there's double days. Like, I'm completely willing if you can extend it. And I was gonna pay off my whole fine today. Is it 300?
300 is...
Yeah, I was gonna pay it completely off.
Okay.
But like, he just has to go to UK every 6 weeks now. Like, he's, I mean, a lot better. But like, we literally lived there all summer. And if you need me to bring in, like, to show you that I'm
I'll
being,
take your word for it. You're
Okay.
gonna pay off your fines today.
okay.
And I'll set your next review hearing for November the 18th. If you get everything done before then, you don't have to come back.
Okay, and does that mean you're off probation too for it?
Yes.
Okay,
November the 18th at 9 o'clock is your next hearing.
okay. All right.
Micah Mayo. And she's finished her community service and hasn't paid her fine off, so it'll be a benchmark for failure to appear. Taylor Parmiter, 23-189 and 191. Are you still at the same Angels Harbor?
Yeah.
Okay, and that, you're with that?
Yes.
All right, do you have a written report or a verbal report you can give me?
Yeah, she's doing very well. She's passing the drug screens and participating like she's supposed to.
Okay. So then that's inpatient?
Yes.
When's she scheduled to complete?
Beginning of November.
Okay. Where are you going to be going after you finish it?
I've applied for housing in Zanesville to get away from my hometown.
Okay, so you're going to stay in Zanesville?
Yeah.
Okay, well, I'd like to have a written report when she finishes.
Okay. They're supposed to be sending weekly reports to,
Mr. Major?
yeah, couldn't think of his name.
Okay, well, they're not in the file. I'll set your next hearing for November 25th, so you should be finished and out. Will there be some sort of aftercare program?
Yeah, outpatient.
Yeah, okay. All right, I'd like to see your report by November 25th, and you'll still have some fines to pay too.
Okay.
November 25th, 9 o'clock.
Thank you.
You're welcome. Ben Smith, 23662, is that Bethesda?
He also paid $100 on his fines as well.
Okay. Okay, you've got 4 hours of community service left to do.
Okay.
So, not even a full day, but
Got this at Gold Pound Market?
yes,
All right.
that's fine.
I'll go there and talk to them about it.
And you're gonna pay your fines today?
I paid $100 today.
Okay. Oh, yes, you've already paid. It's in the file. Okay. Good progress you're making then, keep it up.
Sure.
I'll set your next review here for November 1st,
Thank you.
11/1.
Thank you, Your Honor.
You're welcome. 9 a.m. November 1st.
Jason Collier, Dakota Kraft, Ashley Huff, Elizabeth Monk, Donald Porter, and William Rice.
Jason Collier, 22275. to pay off your fines. Do you have a payment today?
Yes,
How much are you paying?
50.
Okay, see the clerk. And I'll set you for November 1st. You finish it up. Before then, you don't have to come back to that hearing. 9 o'clock, November 1st.
Thank you, Your Honor.
You're welcome.
Cameron Cox. Cameron Cox.
Okay. Wrong there. I didn't see the other files. Dakota Craft, 2320,
May I have first, Your Honor?
yes, and 22130. Is that Bethesda? Okay, it's a very good report. Got a good job.
Thank you, sir.
Made a lot of progress.
Thank you.
Can you pay anything on your fines?
I paid $45 2 weeks ago, and I just got a job at Snack Shack, so I'll be putting more money on my fines soon.
Okay, that's fine. November 1st will be your next review, 9 o'clock.
Thank you, sir.
Thank you, Your Honor.
You are. Ashley Huff is here, 2758, 2724. And you're down to, looks like $60 is all you have left to pay.
Okay.
Are you making payment today?
Not today, sir.
Okay. When do you think you can pay it off?
I'm hoping next time I come,
Okay,
you said 60, right?
60.
Okay.
November 1st will be your next hearing. If you pay it off before then, you don't have to come in.
Okay.
That's all you got left. So,
All right.
good job.
Thank you.
Elizabeth Monk, 2167, 2867. And you made a payment September 9th.
Yeah, I'll have one before is when I get paid.
Okay.
I should have one down to like 40, right?
I got 310 on 2167 and $35 on 2867. All right, November 1st will be your next review. 9 o'clock. Once these are paid off, you don't have to come in anymore. Donald Porter.
Yes, sir.
2803, 181242, and 08441. You're paying off your fines on payment today.
Yeah, $20.
Okay, see the clerk. October 28th is your next hearing.
No, thank you.
William Rice, 2024-04, 182548. Has not appeared, so the bench warrant. That finishes reviews. We're starting arraignments now. Arraignments are what new cases, that's the hearing on a first hearing on a new case. So anyone out in the lobby that's got an arraignment, they need to come in now. You have a right to remain silent. You don't have to say anything when you're called before the court. If you do say things, what you say is on the record, so if you admit something about your case, the state can use that against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to be considered for bail and to make the state prove any charge against you beyond a reasonable doubt. So when your name's called, come up to the table to your right and stand there. I'll go over the charges with you. If it's a misdemeanor, I'll ask you for a plea. That's your answer to the charge. If it's a felony, the more serious charges, you won't even be asked for a plea at the first hearing. If you're not sure what to do, if you want to talk to a lawyer, if you want a trial, any of those reasons, you should enter a not guilty plea. If you're enter a guilty plea, you're waiving those rights I just explained to you. You shouldn't do that if you don't understand what's happening. And you shouldn't do it just to get the case over. That's not a good reason to enter a guilty or no contest plea. Call the first case.
State of Ohio versus Heather Humphrey, case number TRC 24-1981.
Hello, Your Honor.
Good morning. You're Heather Humphrey.
Yes.
Ms. Humphrey, the state's filed a complaint alleging that on September 20th at 12:35 a.m. in Union Township, you were driving a vehicle under the influence of either alcohol or drugs, and that this would be your first offense in the look-back period. The maximum penalty is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most that can happen. There is a minimum, so there's a level I can't go below by statute, and the minimum is 3 days in a treatment program, $375 fine, and a 6-month license suspension. So that's the only charge you have. Do you understand that charge and the possible penalties?
I do, Your Honor.
Do you understand the rights I explained defendants have?
Yes, sir.
How do you wish to plead to these charges?
Under my circumstances, not guilty, Your Honor.
Do you wish to be considered for a court-appointed lawyer?
Yes, please.
Are you working?
Yes.
What do you do?
I'm a manager at Beltone Hearing Aid Center. I've been there about 4.5 years.
Okay, I have to determine your gross annual income, so you gotta help me out. Do you know what your gross annual income is, or what do you make a week or a month? Some way we can figure it out.
I would have to pull up like my pay stub and things.
Are you paid by the hour?
Yes.
How much per hour?
Around 16, 17.
And, or is that a 40-hour work week?
Yes.
Do you have any dependents? Do you have children? You're a single person?
I get a lot of overtime sometimes, so sometimes.
Well, I'm getting that you're making about roughly a little over $35,000 a year gross. Does that sound about right?
That sounds about right.
Okay, well, actually, for a single person, that's more money than what I can appoint counsel for, so.
Okay.
You can have a lawyer, you should probably have a lawyer, but you'll have to hire one on your own.
Okay.
So, I'm entering a not guilty plea for you, and it's going to be a while before we come back for a pretrial, so hopefully that'll be enough time for you to make arrangements to hire a lawyer.
Okay.
So let's see. For you working Monday through Fridays?
Yes.
Does it matter what day of the week you come back?
No, they'll work around this.
Okay.
I've already let them, everyone at my work know.
Okay, let's do it then. This is unusual because usually the court hears on Mondays and Fridays. But the week of the 14th is a holiday. That's Columbus Day, so the state offices are closed. So we will have court on the 15th. That's a Tuesday.
Okay.
So I'm going to set your next hearing then. That gives you over 3 weeks to make arrangements to get counsel.
Okay.
So you come back October 15th unless you retain a lawyer and they tell you, well, I'm going to change it to, they may be busy that day. They can ask the court to continue it to a different day. When your lawyer tells you to, if it's a different day.
Okay.
Otherwise, you got to be here October 15th,
At 9 a.m.?
10 a.m.
10 a.m.
So we'll hopefully start pre-trials around then. I'm going to let you sign a signature bond. What that means is a signature bond of $1,000.
Okay.
And that just means you're promising to come to court as ordered, or you'll pay a $1,000 penalty if you don't show up, and you get a warrant for not showing up. So that's the worst part.
Yes, Your Honor.
As long as you come to court, you won't ever post any money to secure your appearance.
Okay.
I'm putting down you will hire counsel.
Okay.
Do you have any questions, ma'am?
No, not at this time.
Okay. that's
Thank
all.
you, Your Honor.
You're welcome. October 15th, 10 o'clock, is your next hearing.
Thank you.
State of Ohio versus Brian L. Clay, case number CRB 24560.
All right, you're Brian Clay.
Yes, sir.
Celeste, you had a hearing on Friday and we're here.
Yeah, I was at King's Daughters Hospital. I went there Thursday morning. My asthma and things flared up and stress test, and I just got out yesterday afternoon.
Okay. You got some paperwork on that?
Yes, sir.
Your lawyer is not here today, Mr. Smith's not on the docket. Okay, is this mine to keep?
Yeah, you keep that, yeah.
All right, we'll keep that. I'll excuse your absence then, I'll continue it. Is Roger in here?
Yes.
Let's ask him to come out. Okay, I'm not appointing you, I just need to ask you a question.
Yes,
You're not your brother's keeper, but this gentleman is being represented by your brother, and he's not here today. Do you have any knowledge as to when he's going to be back?
I do not, Judge. I can find out, but I don't know offhand.
Okay, why don't we do that? Can you text him or something? Find
Yes.
out?
What's your name?
Brian Clay.
Brian
Okay,
Clay.
Brian
Brian, if you just have a seat, this is Tyler.
See back out here, sir?
Yeah, and
I'll find
we'll
out.
find
Judge.
out, then we'll get a date set when he's going to be.
Yes.
Thank you.
State of Ohio versus Stephen Wilson, case number CRB 24172, A and B. This is just a workers' case, Your Honor, but I'm not sure if it's here or not.
Need Mr. Morford in the courtroom? All right, recall, your lawyer's not here yet, so sad seat.
State of Ohio versus Jordan Maynard, case number CRA 24427.
This is for arraignment.
Are you Jordan Maynard?
Sir, you Jordan Anthony Maynard.
Yes, sir.
Mr. Maynard, it's alleged that at Rome Township, May 27th of this year, you purposely deprived Carrie Ward of property by deception, being more than $1,000 but less than $7,500. So that makes it a felony 5 theft offense because it's over $1,000. Maximum penalty for that's a year in jail, $2,500 fine. Do you understand the charge?
Yes.
Do you have the money to hire a lawyer?
Yes.
You have hired a lawyer?
No, I have to. When I didn't know anything about when the court stuff got sent, I live in a different area. I live in Columbus, well, Cincinnati, but Columbus area. I haven't lived in West Virginia, and they sent the court papers to West Virginia that's why I wasn't here the first court date.
Okay. Well, you've got a bond posted now, so.
Yeah, I know. But I was.
You don't want to be considered for a court-appointed lawyer, you want to hire your own lawyer?
I mean, if I can get a lawyer, I will.
Are you working?
Yeah,
What do you do?
construction.
Are you paid by the hour? How much per hour?
21,
You have children? How many?
2.
Okay. Well, let me figure out, I have to figure out what your gross income is. So you're working 40 hours a week?
Yeah. And if there's any way, by any chance, I could do 3 or 4 payments, just pay it restitution wise, I can do that. I just didn't know.
Well, that's the prosecutor. They decide on how to proceed, if they want to press the charges.
I didn't know who to pay when it all took
Well, as
place.
of right now, that's not we're not at that point. Does the prosecutor have any idea what you would want out of this?
I believe it's $2,700,
Yeah.
and we'd be interested in payments as long as it didn't take forever.
No, it'd take me 4 tops, maybe even 2 or 3. But would I?
But how long
would
would
do?
it be?
Oh, it's September. I can get it done by the end of November.
Well, we're interested in that, for sure, and that would help us not have to take the case to the grand jury.
Who? If
He could
do
hear
I
it.
ask him? Who
He's
do
the
I pay?
prosecutor.
Do I pay you, the office? Do I pay them?
Can they take partial payments on restitution?
We can pay it here at the clerk's office.
So pay it here,
Yes.
and then.
So here's the way this works, Mr. Maynard. It's up to you. You can still have a lawyer if you want to hire one. I'm still looking to see, meet the criteria for appointing counsel. Take your time. Well, I get you're making about $43,000 a year. Does that sound right?
Yeah.
Okay, I'm going to go ahead and appoint counsel for you. Here we go. Okay, I'll appoint Mr. Holt.
If you do restitution. Restitution payments be made online?
I'm not sure about can. Okay. Mr. Holt, this is Jordan Maynard. He has a felony 5 theft. There's already been some discussion about restitution and keeping the case here if he makes restitution payments.
We need to talk.
Can we recall this, Your Honor?
Yes. Okay, I'll recall.
State of Ohio versus Courtney Corbin, case number CRB 24614.
And ma'am, you're Courtney Corbin.
Yeah.
Ms. Corbin, it's alleged that Fayette Township on September 22nd, you knowingly caused and tried to cause physical harm to Christopher Meade, that Christopher is either a member of your family or lives in your household. So that's a domestic violence charge, maximum penalty is 6 months in jail with a $1,000 bond. You understand the charge? Yes.
Yes,
You understand your rights?
yes,
How do you plead to this charge?
not guilty.
You want a lawyer appointed?
Yes,
Do you have a job?
yes.
What do you do?
I work for HHS at Marshall.
Paid by the hour?
Yep, $11 an hour,
How much?
11.
Okay, you're eligible for court-appointed counsel then. Austin?
Mr. Morford is here now, Your Honor.
Is Mr. Steyer?
Yes, he's here.
Mr. Steyer will be appointed. All right, Mr. Steyer, this is Ms. Corbin. I'm appointing you to represent her. Not guilty pleas entered. We need one from prosecutor. Is there a protection order required?
Your Honor, I have a Christopher Mead that I actually am representing here today. I don't want to make sure if it's not the same individual.
It is.
Then I can't, I'm currently representing him in another case.
All right, let's give Mr. Smith.
Chris Vernon? Let me go get the rest.
All right.
Oh, I did right here, so I apologize. He actually does not want it, but actually.
Okay.
All right, I think I overheard him say he does not want a protection. What's your connection?
Your Honor, I'm speaking with Mr. Mead here. He's the alleged victim in this, and he, first of all, does not want a protection order. They have children together, but he also believes that there's some substance abuse issues that need to be addressed, and he's concerned about that, of course, because they have children together. So we would propose a continuance of this matter and allow Ms. Corbin to be assessed for treatment and find a treatment provider. Apparently, she's not in favor of that, so.
Judge, we're okay with that. How do you pay for medical? Do you have-
Medicaid.
Okay, she has Medicaid, Ohio?
Yeah.
Ohio Medicaid, Judge.
Okay.
She's the one to do
Lives in
that.
Chesapeake,
Lives in Chesapeake.
Yeah,
Township Road 148, what's that?
yes.
Where is that?
I'm at Buffalo Creek.
Okay. That's kind of South Point-ish.
Yeah,
That's not real Chesapeake.
it is not.
But, have you been to treatment before?
No,
Okay.
I don't believe I need it. We went through cases with him, and that's what I told them he needed was a recommended rehab, and it's just, he's trying to fall it back on me.
Well, you can go get an assessment at least and see what they say.
Okay.
Fair enough, Judge.
That's fine.
I think Hometown has availability for females.
Well, this is probably going to be outpatient.
She's outpatient.
Okay. All right, I'll refer you to Bethesda for an assessment.
Just, what is that at?
That means they're going to talk to you and see if they think you need counseling. And then we'll come back for a pretrial.
Yes, sir. Judge, the
October 7th.
I'm gone on that Monday. I'm available the 11th, and then I'm not available till the 25th in October. Or I could do the 4th.
This works. The 11th is better.
I can do the 11th.
Okay, October 11th. Be the next hearing, pretrial.
Thank you, Judge.
So, Ms. Corbin needs to speak to Taylor from Bethesda before she leaves there.
Yes, sir.
She's down the long list, waiting for
State of Ohio recall Stephen Wilson, case number CRB 24-172, A and B.
It's Mr. Morford's case.
Your Honor, that's just an admission letter. Stephen got to us about a week ago. He was a self-referral, and he has been in and out of the hospital and urgent care since coming to us, so we don't have a lot of information to give you about his progress, but he has been compliant.
Okay. But he is inpatient?
Yes.
So he's been in other medical, but coming back to you when he's finished with it?
Yeah, like we go with him, staff goes with him, and he's just had some complications with his arm and
Had a
stuff.
blood clot. Had to have surgery.
And he was there before, right?
He was. He completed before.
All right, Mr. Morford.
Judge, he is back in treatment, which is where he says he wants to be. I can address his failure to appear and try to distill his situation, if you like. Essentially, Judge, he has a father with dementia that he had to get situated in a nursing home. I'm not sure what mom's role was in this. And then Mr. Wilson drank a bottle of liquor, went to KDMC to detox so he could get to Shawnee Mental Health. He does not have an operator's license right now, Judge.
I done it on purpose. If I could explain real quick, Sunday night, the victim, the alleged victim in this case, Priscilla Carter, which is my mother-in-law, they was wanting to have a cookout, and I said there's a protection order, they can't come out here. Well, she was telling my wife that she told Mr. Hill she wanted the charges dropped and the protection order dropped. I said, well, it was never said in court. So this led to my wife and me, her saying that I just don't want her family around, blah, 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 and she took off Sunday night. That's why Monday morning I called in here and I had no way to get here. She didn't show up. So I had all week to get Dad in a nursing home and to find a way to get back into treatment. So as soon as I got him in a nursing home right there in Portsmouth, because I knew I was going to go back to Shawnee. It's like a 1.7 miles, I'm just walking distance. And I door-dashed a bottle of liquor, drank it, and then called an ambulance. And the only thing I wasn't planning on was their 72-hour hold, or I would have made it here that Monday. And I had contacted Leslie and told her that because I have no way for his doctor's appointments now to make it to court or whatever. So I want to stay with Shawnee until I'm independent.
Okay. Well, I can agree with going back to treatment. The method of your going about it, I don't think was necessary, that, what you did, but you're where you need to be now, I think so. We'll kind of reinstate you there and monitor your progress as you go along. You've done it before, so you can do it again.
Yes.
Okay, let's come back. October 15th, are you available then, Mr. Morford?
I am, Judge.
Okay, October 15th is the next hearing.
But I was right about that. This protection order was still good, wasn't it?
It's still in effect.
Okay, that's exactly what I thought.
Thank you, Your Honor.
Thank you, Judge.
If they want to drop it, they can come into court and ask the prosecutor to drop it.
That she was saying she done asked for the charges dropped and the protection order dropped. Miss Priscilla.
State of Ohio recall Crystal McMillan, case number CRB 16688. I was told she's here now, Your Honor.
Crystal McMillan. Crystal McMillan. Okay, I'll pass it to the end.
State of Ohio versus Philip Hill, case number CRB 24218. Your Honor, this is Mr. Holt's case on pre-trial.
Need Mr. Holt in the courtroom.
Your Honor, it's my understanding this was to be dismissed. And for cost, there has been no further issues.
Well, that's not our understanding, but I will say this, that the alleged victim in this matter, Julia Hill, is a defendant in a case in which there's a special prosecutor, and the next hearing is set for September the 30th. And so we believe the best thing to do is to have both of the cases set on the same day and see if the parties can agree with each other that how they want to proceed, whether they want trials or whether they're willing to dismiss the charges. They've got a divorce pending, and these, as often happens, these criminal charges get wrapped up in that, trying to gain an advantage over each other. And
I'd like to respond to that, Your Honor. We've discussed this. It doesn't matter if there's a divorce. We've had discussions about this case prior. It's a ridiculous charge. It's a violation of a protection order before he was served, and he didn't even violate the terms of it. After we indicated from the get-go that my client was not interested in pursuing criminal charges, even though his brother is the actual victim. But I don't know. All this is going to happen is that now Mr. Hill's going to pay me more money to come back another time. I don't understand that.
Well, I had no notes of any agreement that it was going to be dismissed, or, I mean, I can't make the prosecutor dismiss it.
I know. I just wanted to get that on the record, Your Honor. There was an agreement.
Are you available on the 30th?
No, I'll be in federal court, Your Honor, for the morning.
Who's representing the other party?
Mr. DeLauder was, but I believe he resigned. He resigned in both the divorce and the... I don't know if he was representing her in the criminal matter or not. He did resign in the divorce. The divorce is also set for a hearing on the afternoon of the 30th.
Well, let's set this for some time after that then, since you're not available on the 30th. If the divorce is resolved, sometimes it tends to resolve the other.
This divorce is, I'm fairly certain, is going to go to trial.
On the 30th?
No, it's a preliminary hearing or pre-trial about Mr. Hill to get full custody.
Mr. Morford
represents Julia Hill in her case here.
Okay. All right, how about sometime latter part of October?
Would the 18th work, Your Honor?
Yes.
That work for you, it's a Friday.
Okay, October 18 will be the next pretrial, 10 o'clock.
Your Honor, Mr. Maynard's case that you had me speak to, I don't think he qualifies for court-appointed counsel.
Okay. We can recall that. Ward Maynard.
State of Ohio versus Gordon Maynard.
All right, so we're back to, you can hire counsel if you wish. Perhaps if you work something out in the state, they said they would be interested in keeping it here for paid restitution.
So, will I work, when you say that, work it out now?
Well, you can pay the restitution to the clerk, but since this is a felony, in the course of things, it would go to the common police court in Ironton, which is the
What,
felony court.
the payment would?
No. If it went to trial, what I'm trying to explain to you is the process, and I know it's kind of, if you're not a lawyer, it's a little bit hard to understand. Your case gets filed in this court, and the first hearing is here, but after that, it goes on to the common police court where you would be indicted. Felonies are so serious that your fellow citizens have to look at the case and say, yeah, this guy needs to be charged. That's what an indictment is. But what they're saying is, if you're willing to pay the restitution, they won't take it to the grand jury and indict you. They'll just keep it here and let it pin for a while to see if you're going to pay the restitution.
Yeah, that's
Okay?
right.
And that's a pretty good deal on your part.
Right.
But you can get a lawyer to advise you on that. I'm not your lawyer, but if you don't get indicted, that's a good thing.
So if I want to do what you just said, the second one.
You want to keep it here and pay restitution.
Yeah.
Okay. So, and you're living out of the area now, you don't live here now?
Yeah, I haven't lived here almost 8 years.
Okay. So here's my suggestion, let's go about a month out, set another hearing date, and hopefully you can make some restitution payments between now and then, or pay the whole thing off, come back, and
If I make,
you're welcome to have a lawyer. You can hire a lawyer at any point. Yes.
if I make a payment all at once, to, like, what's that entitled? What's charges and like, what's?
Of course, if we agree to keep the case here, then it implies that it would be a misdemeanor charge. The cause of this case is just now coming before me. I have not spoken to the alleged victims in this matter. So it would come down to the question of whether we would agree to dismiss the charges if he makes the payment promptly, or whether we would still be pursuing a misdemeanor level theft charge. So I don't have an answer to that right now, but I think that the quicker that it's paid, the more likely it is to convince me and the alleged victims that it's okay to dismiss the charges.
Fair enough.
Okay, so we want to go a month out for, roughly a month out, let's make it October 21st for the next hearing.
Yeah, that's fine. Can I do that right there? The virtual or whatever?
If you've made a payment, I'll let you appear by teleconference.
All right.
A substantial payment by October 21st.
Oh, no, yeah, that's fine.
And I'm going to let you sign a bond of $2,000, signature bond. You understand what that means? Bond is your guarantee that you're going to appear in court, so I'm letting you be your own guarantee. You're saying, I'm signing it's like an IOU. I'm signing an IOU to the court for $2,000. If I don't show up, I owe you $2,000. If I show up, I don't owe you anything, as long as you show up.
And even if I show up on the screen, right?
Yes, as long as you have permission to show up on the screen.
Right.
We'll also need a
Time waiver. You have a right to have this case heard in a certain time frame because we're going to continue it at your request. You're waiving your time constraints.
It's a time.
Okay, Mr. Maynard, any questions?
Thank you.
Get this paid off, and then if it's not paid off by the 21st, appear either in person or by teleconference, and you can get either from the clerk or the probation if you need to sign in. There's a link you can go to get on the teleconference.
All right. Do I need to do anything right now, or do I just, we're good?
No. Okay, October 21st is your next hearing.
State of Ohio versus Henry Rogers, case number TRD 24168, A and B. This is listed as
Okay, it looks to me like this is I've got a note saying this is a sentencing, but it looks like it's an arraignment. Have you appeared in court before?
No, sir.
Okay. TRD 24-168, A and B. It's alleged that on January 26th of 24, so I don't know why this case is so delayed, you were driving a vehicle without a driver's license. That's a minor misdemeanor. I'm sorry, an unclassified misdemeanor. Maximum penalty is 500 hours of community service and a $1,000 fine. And not wearing a safety belt, that's a mandatory $30 fine. And you haven't appeared in court on this before?
No, sir, I didn't know you had to. I'm from West Virginia. I didn't know you had to come in for one like that. Usually if we don't show up there, we're just the automatic guilty and then you pay the fine.
Okay. Yeah, it looks like it was set for a arraignment initially February 13th at 4 o'clock. We have a traffic court in the afternoons at 4, and it looks like you didn't appear at that traffic court.
Yeah.
So how'd you know to come in today?
Well, I was trying to get my license squared away and just got my taxes back from a divorce and everything else. So I was like, well, I better get my stuff squared away. Called in and they're like, you need to show up. So I showed up today.
Okay. All right. How do you plead to these two charges?
Guilty.
The officer says, while sitting stationary at US 52 near milepost 14, I checked the defendant's speed above the posted speed of 55. I observed he did not have on a safety belt. He admitted to not having on a safety belt, and he did not have a driver's license. Do you have a driver's license now?
No, sir. I had a ticket in Alabama, a seatbelt ticket in Alabama, a $20 seatbelt ticket in Alabama, and I didn't know that I didn't have it, and that was 3.5 years later, and they finally suspended my license over it, and I didn't, where I moved, I didn't have no way to get in contact, didn't know, and he's like, yeah, you got something in Alabama that's got your license suspended, and so I went ahead and took care of it, and now I'm waiting on to take care of this.
And you're living in Huntington?
Yes, sir.
Anything you want to tell me about this?
I'd like to pay it.
Okay, well, it's going to be more than paying. Okay, on the no driver's license, I'm going to send you to 18 hours of community service. That's 3 days of community service. And a $150 fine. Yes. And on the safety belt, that's a mandatory $30 fine. So.
What $100 fine on the NOL?
150. 150 on the no operators, 30 on the safety belt. And that's more than it would have been if, you got to get something more for not coming in.
Yes, sir.
So you would have got less if you would have come in when you're supposed to. We have a community service program here at the court every day, but Sunday you can do community service at 7:30 a.m. here at the court. You probably won't stay here, but you can report here at 7:30.
Yes,
Go
sir.
someplace to do community service. So I'm going to do it as a, rather than a probation, I'll just make it a final pay date. So you got to get this all done by December 24th. If you don't, then we're going to send it in as to Ohio. You don't have a license, but they'll tell all the other states that you shouldn't be allowed to get one, to keep you from getting a license.
So when I pay off this fine, even though I haven't done the community service yet, will I be able to get a reinstatement and start my license?
You have to get your community service done.
10-4.
Once you get it all done, then it'll be cleared. So, and there's a date, 2 days coming up. Well, if you come out on the 5th, you get 2 days for credit for doing 1 day. So it's a township cleanup day, so to encourage people to come out, we'll give you 2 days. So you can do that in one other day and you're done.
Sweet.
If you have questions about what you need to do, probation officer, I'm not putting you on probation, but his office to the left, he can fill you in, he can be your contact person. This gentleman, Mr. Cooper, is in charge of community service. That's who you'll be working with to get your community service done. Do you have any questions of me?
No, sir.
Okay, that's all.
State of Ohio versus Joseph Atkins, case number CRA 23-260, CRB 23-261, CRB 23-356. Your Honor, this is a preliminary hearing.
This is Mr. Smith's case.
It is, Judge.
Mr. Tyler Smith, I've got one of your clients is here.
Mr.
Just a hearing before Brian Clay. Is Mr. Clay still in the courtroom?
Yes, it is. Yeah.
Okay, here. You want to take the court's file, talk with him, and then we need to set a new date.
Go back down to it.
Now, talk to Mr. Smith first.
That's what I thought.
Okay, very good. His report. Looks like you got a job ready for you. So you ready to wrap things up soon? What's the state want to do?
Your Honor, there's 2 theft charges that were pled to previously and still need to be sentenced. They're both Walmart, and one was in June of 23 and when the other one was. But he's done very well in treatment. And as far as the possession charge, I don't know whether we want to get him across the finish line before we dismiss it, but if it's appropriate to dismiss it today, we don't oppose that. I guess
Defer to Taylor. Which on the spot?
I believe he's good. I say that because you know. But, I mean, I think he has his, I mean, it's on him now. He has a job laid out. He's done really well in treatment. You know, he has a new life laying at his feet, so it's on him.
Well, and if the court would require him to finish his treatment as part of his probation on the theft charges, that should satisfy that.
Yeah.
We're good with that, Judge, yeah.
All right, so on 23-260, that's a felony, that'll be acknowledged. So the most serious charge is getting dismissed.
Thank you.
And you have a right to say something if you want, you don't have to, but whenever you get sentenced, you have a right to make a statement if you want to make a statement. Do you have any statement you want to make?
I just want to say thank you.
Thank you for taking advantage of your opportunity and making the best of it.
Trying to.
There's going to be additional challenges for sure.
Yeah.
But as I second what Taylor said, is you learn what to do. It's kind of going to be on you now to make sure it keeps happening.
Yep.
Okay, so on 23-261, it's Walmart theft.
Didn't sentence you, but I got the sentence. We'll sentence you down around. Just a second.
Okay, I'll impose a $50 fine. Cost be paid, 20 days in jail, all suspended, 30 hours of community service, finished treatment with Bethesda. stay out of Walmart. I'm sorry? Level 5. I think it's fine. Set not so far out in the future. Let's make it December 20 for review. Then there's 356.
Let's see what happens from here.
It's also theft from Walmart. $50 fine, court costs, 20 days in jail suspended. Finish treatment with Bethesda, stay out of Walmart, 30 hours community service. So you got a total of 60 hours. And December 20th review day. Okay, to give you a little further favor, based on your doing well in treatment, I'll just, you had a really old traffic case that you never took care of.
Possibly. It's from 2018, that one.
Yeah.
Yep.
That's 18/24/12. I'll dismiss it.
Thank you, Judge.
Yeah. Okay, he'll need to meet with Mr. Major.
Thank you, Your Honor.
Thank you. You're welcome. Thank you.
State of Ohio versus Alyssa Porter, case number CRB 24563.
Mr. Smith's case set for pretrial.
It is, Judge. I got the DVD Friday. I have not had a chance to watch it with my client yet. I spoke to Mr. Hill. We would wait time for us to come back, so I have a chance to view the DVD with my client. The 11th or 25th of October would be good dates.
25th, the 11th is pretty full.
Okay, be fine, Judge.
October 25th is for pretrial. 10 o'clock.
State of Ohio versus Aaron Williamson, case number TRC 192164.
It's Mr. Smith's case.
It is, Judge. This is a case that goes back 5 years. I've located my file, not yet had a chance to talk to Mr. Williamson. He just appeared last week. Yes. I would ask for the same date if we could. We'll waive time to get him in because I've not seen him for 5 years.
This case was never resolved, right?
It's still pending. I filed discovery back. I found my file. It's just nothing happened. We had a pretrial set, and he just, for whatever reason, didn't appear. But he's back in the fold now. He says he will be here. He showed up today when you let him out of jail. I have every confidence he will. He wants to get this resolved.
Okay, October 25th for a pretrial at 10 o'clock. Is there a bond posted on this, or did he post a bond?
Yes. Did you get your post with Sowers? Yes. Mr. Sowers, he says, Judge.
Okay.
Last time I saw him, he's in
I don't
jail.
see the bond, but my note was 1,500 cash insurance.
State of Ohio recall Brian L. Clay, case number CRB 24560.
This is Tyler Smith's case.
Yes, Your Honor, I had a chance to talk to Mr. Clay, and I believe that he provided an excuse for why he wasn't here Friday, and I'd asked maybe we'd come back this Friday for his first pretrial. I've talked with his treatment provider. They're going to bring in a full report of how he's doing.
Okay, we'll do that September 27th. Pretrial.
All right, thank you, Your Honor.
10 o'clock.
Thank you.
Your Honor, I do have a question.
What's your name?
Excuse me, I need to ask the service provider.
Probably just,
The gentleman that is alleged to have been the victim, do you know where he is now?
I don't know. He took off the ASA, so I'm not sure where he went.
What date are we coming back, Your Honor?
Friday.
Thank you.
State of Ohio versus Kia Maynard, case number CRB 24478.
Mr. Stratton's case.
Your Honor, we've got the video now, we've got all the discovery, so, we'll just, set it for trial, Your Honor.
October 7th
Yes, Your Honor.
at noon.
Yes. No, so you have to come until 12. All right.
State of Ohio versus Jared Sipple, case number CRB 24433.
Mr. Sipple was at PATH, Your Honor. We should have a report. Not sure where he's at. Well, sure where Mr. Sipple is at, Your Honor. He was here on the 23rd of August. He had a good report from PATH, so I'm not sure where he's at.
Okay, so you have 7 days to get in before warrant issues.
Yes, Your Honor.
State of Ohio versus Richard L. Taylor Jr., case number CRB 24469.
Just going to get the video of this case.
Mr. Stratton's case, pre-trial.
What is the name?
Do it. Richard Taylor. Your Honor, we still need a video in this case. We had spoken about a video last time, and we have not received that just yet. So I ask this be set for another pretrial.
October 7th?
Yes, Your Honor. You'll wait outside and I'll talk to you. Okay. Give me a few minutes.
State of Ohio versus Ashley Wallace, case number CRB 24557. Ashley Wallace.
When was Richard Taylor? We do have a video. We do have a video. Okay, great.
I'll tell him to see that too.
Okay, I've seen it here.
Should be here tomorrow.
So in the balance, we need a video. Oh, there it is.
Your Honor, this is the first pretrial with Ms. Wallace. I think there's some stuff that we still need to receive from the prosecutor. We just ask this be reset for another pretrial.
October 18th?
Yes.
Is that on a Friday?
It is.
Is there any way we could do it the week before or after? My son has an appointment at Cincinnati Children's Hospital.
I can make it the next Monday,
Okay, that's fine.
The 21st?
21st.
I appreciate it. Thank you.
Yes.
Thank you very much.
October 21st.
Thank you.
For the pretrial.
State of Ohio versus Brian Marchberry, case number CRB 24590 and CRA 24362.
Tyler Smith's case.
I haven't published
Three separate ones.
No, because I'm here in court.
Yeah, three separate ones.
We can get voicemails like in other places when we're here. Yeah. Are you sure? Honestly, this is the one. We got these additional charges.
I'm not dropping the case.
Sorry.
Yeah, that's right.
But you want drop the protection? Did you really find another place to go to? You're not, he's not going back where you're going. I have a place to go in that
Your Honor, Ms. Haycock is here, and she's indicated that she doesn't want the protection order. We've got a felony pending, and we've been patient in that matter with hoping that Mr. Marksberry would do the counseling that I believe was ordered previously. So we want to know if that's happening, first of all.
He's currently in anger management treatment. He had an appointment today, another appointment today.
Pardon?
He has an appointment today. He's been in anger management.
Who's he seeing? Who's he go to?
Brad Poe at ODP National.
We'd like to see a report.
I just gave the judge 3 copies, but they're 3 different ones. We'll need copies of them.
Thank you. Apparently he's attending sessions.
So how's the state want to proceed? So you're asking for the protection order to be dropped, is that correct? Okay, and that was issued on 25/9, so that's dropped.
There's 2 numbers.
Hey, Cook?
Yes. We issued it off the first, remember, we did an arraignment on him on court.
No, I know that. I understand. I'm doing this for you.
Oh, sorry.
I guess we're okay with the further continuance as long as he continues in his treatment and agrees to a time waiver.
We'll wait time.
Come back in a month or so?
That's fine, Your Honor.
21st of October?
That's fine.
October 21 is the next hearing.
Your Honor, we're ready to go to the Lawrence County Jail, State of Ohio, which was Christopher L. Collins at the Lawrence County Jail, case number PRC 24-1976, ABC, CRB 24-613, A and B, and CRB 17-866. Brandon Spencer is on deck.
Yeah, we're waiting on the jail to do something here. No, they're there, they're ready. Sir, are you Christopher Collins? Okay, Mr. Collins, can you hear me okay?
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court. You're appearing in court here today by a teleconference on a monitor where what you say is being recorded. You have a right to remain silent. You don't have to say anything. If you choose to make statements, it's on the record what you say that could be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove these charges beyond the reasonable doubt. Those are the rights all defendants have. Do you understand those rights?
Yes, sir.
Okay, we're going to start with case number 24-1976. That's a traffic matter. It alleges that on September 21st, 2024, at 2:55 p.m. in Rome Township, you were driving a vehicle while you were under the influence of either alcohol or drugs. and that you refuse to take any tests. So I believe that extends the look-back period for 20 years. So this could be considered a third offense under Ohio law, because you've got alleged violations of a similar statute in 2006 and 2007. So on a third offense, the maximum penalty is a year in jail, $10,000 fine, I'm sorry, it's not 10,000, it's $2,750 fine is the maximum, 10-year license suspension, and a year in jail. And also, if the vehicle's titled to you, it can be forfeited to the state on a third offense. Now, there's minimum penalties on a third offense, and the minimum is 30 days in jail, $850 fine, and a 2-year license suspension. The state's also alleging that you had a child in the vehicle of a size or age that needed a safety restraint and didn't have that. So that's a mandatory $100 fine on that offense.
Yeah, I didn't have my daughter bought me in.
Okay.
I was in the room when I left the house to go get my wife from work.
Okay, Mr. Collins, let me caution you again. What you say is on the record. Everything you say is on the record. The prosecutor's sitting right here, so if you make statements like that, they can use those against you. Admissions in the law are a big deal. When you say something out of your mouth, you're pretty much stuck with it. The law's going to make you stick with it. So it's best not to say a lot. Okay, the last traffic charge is failure to control your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. Okay, now there's a criminal charge that goes with this. It's 24-613A and B. It's two counts of endangering children. So apparently there was 2 children in the car. It's alleging that you were the parent or custodian of children under the age of 18, that you violated the duty of care, protection, and support by risking their health by placing them in a vehicle while you were under the influence. So that's first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. So those are all the charges with this September 21st incident, I believe. And you've got an old case from back in 2017. That was a theft offense. It's alleged that you had a theft conviction, that you didn't finish, that you didn't pay your fines, and you didn't finish your community service, and you got a warrant on that also. So you can get any penalty that was suspended for that offense. Okay, do you understand these charges?
Yeah.
How do you plead to these charges? You don't have to plead the same to the charges. You can plead differently.
I'm guilty of them. I mean, there's no other way around it.
Well, this third offense, let me say it this way.
That, what for the drop, out there?
Yeah, driving under the influence?
May I approach for a second? Ron?
Yes. So it's the same. Okay, the prosecutor has approached the bench, and what he's told me is that what they're considering this is not a third offense, but it is considered A first offense with a prior refusal in with a refusal in a prior in the last 20 years. So that does raise the penalty. It's not as much as a third offense, but it's a still first-degree misdemeanor. The maximum penalty is 6 months in jail, a 3-year license suspension, no forfeiture of the vehicle.
Okay.
The minimum penalty is 6 days in jail, $375 fine, and a 6-month license suspension.
Okay.
So that's what the penalty is on your OVI now.
Okay.
That's the range of penalty.
Okay.
Do you understand that?
Yes, sir.
So, okay, back to the question, how do you want to plead to these charges? As I said, you don't have to plead the same to all of them, you can change it.
Yeah. Guilty.
Okay, if you enter a guilty plea, that's an admission that the charges are true, it waives your rights to have a trial and have a lawyer. Do you understand that?
Yeah.
Okay, I'll accept your guilty plea, and I'll ask Mr. Heel, well, let me read into the record, I guess, because I have no idea what the underlying facts are. I'm going to read the officer's report into the record on this, and then we'll ask the prosecutor if he has a recommendation as to what the penalty should be. And it looks like it was a one-vehicle crash here. There was a crash, but I don't think there was...
No, yeah, I just went off the side of the road right there. It's like, I mean, it was, yeah, I just veered off the road a little bit.
Okay. Okay, the officer says, I arrived on the scene. I spoke with the witness who was behind the truck. She stated the truck was shoulder to shoulder for about 3 miles. She then watched the truck drive off the right side of the road and strike a tree. After he struck the tree, she checked on all the occupants inside the vehicle. She advised that the driver did not appear to be distracted, but did appear to be impaired to her. I spoke to the driver. He said he had just woke up and was going to pick up his wife. He then advised he fell asleep, and that's what caused him to drive off the road. While speaking with him, impairment was detected. He was given standard field sobriety tests and arrested for operating a vehicle under the influence. He was charged with failure to control, operating a motor vehicle under the influence, and for having 2 children in the vehicle, and one was unrestrained. And then I've got impaired driver report. That was on the crash, which is pretty lengthy. Okay, 9/21/24, I was dispatched to a single vehicle crash, County Road 12. I was advised there was children in the car. When I arrived on the scene, I observed a white Chevy pickup bearing West Virginia plate number off of west side of County Road 12 in a field. When I approached, fire personnel who were there advised the driver appeared to be under the influence. I spoke to the driver and identified him as Christopher Collins. He stated he fell asleep and struck a tree. I advised there was a witness on the scene. I provided a plate to dispatch, made contact with the witness, gives the name. Witness says she was behind the pickup, observed he was swaying from side to side, says there was multiple cars that had to avoid the pickup. She witnessed him drive off the roadway, strike a tree. She made contact with all the occupants for me. She did not notice any distractions such as a phone or radio. I completed my on-scene investigation. Got a statement from Mr. Collins. I observed his eyes were bloodshot, watery. He could not stand still, was constantly moving or swaying. His pupils were dilated. I brought him over to my patrol car. He was given Miranda warnings, asking him about recent drug use. He admitted that he did use meth on Tuesday. Asked him if he had any recent head or eye injuries, said he did not. Observed he was wearing glasses. I observed horizontal gaze and nystagmus, it was not present. Did vertical gaze and nystagmus. Neither left or right eye converged. Attempted to conduct walk and turn and one-leg stand tests, but he stated he could not do them. He did attempt to do walk and turn, but could not go through the instruction phase without stating he could not do it. He also attempted the one-leg stand, but stated he could not do it because of his back. Placed the defendant under arrest for operating a vehicle under the influence. He was searched, taken to the patrol post, offered a urine screen, transported to the Lawrence County Jail where he was incarcerated. He informed me that he had taken cocaine on September 20th at approximately 9 p.m. Also admitted to using meth on September 17th and heroin on September the 18th. He refused to give a urine screen. Okay. All right, Mr. Collins, anything you want to tell me?
Yeah, I just, man, I completed Southern Hope. I've been like 16 months clean. I just screwed up. I mean, that's all I did. Like, past couple days, I screwed up, and I mean, it caught up to me. Like, I mean, I've been clean for going on 16 months now. Like, I finished OVP and Southern Hope, the aftercare program and all that. And I mean, I just fell to the relapse the past week.
Mr. Hill.
I've had a good job. I mean, you know, I've been to work every day and everything like that.
Where have you been working?
Chandler's Plywood. I've had a job there since I was in Southern Hope.
Over in Westmoreland?
Yeah, yep.
Well, we're going to want treatment to be part of this, but I believe probably Mr. Collins knows how lucky he is that that child that was not strapped in was not maybe killed in that accident. He had two children in the car, and one of them wasn't wearing a safety belt, and so it's serious. It's a good thing that Mr. Collins acknowledges his fault in this. He's been in jail, I guess, just 2 days, 1 day, let's see, it's the 23rd, so this is his second day. We believe that there needs to be an imposition of 10 days in jail with an additional 50 days suspended, and then on probation, he should also go back to treatment, and a 6-month driver's license suspension, and we won't take a position on the fine or any other sanctions.
Michael, are you familiar with him?
Yes, I am. He did very well when he was at our program. He's going to be incarcerated for 10 days. We'd love to have him back at the completion of that. It will give us an opportunity to move some beds around and make a place for him.
Okay. Anything else you want to tell me, Mr. Collins?
No, who was that? Who was that accused that said they were people on the back?
Yes.
Yeah, I did so well with him. I messed up. I mean, that's all I did. I mean, and nobody fault mine.
Okay. Well, I'm going to give you a $1,000 fine now. I may suspend some of it later, but it's been my policy for a long time. If somebody refuses to take a test, I give them pretty close to the max fine. Now, if you go to treatment, you're not going to have a whole lot of money. So if you do go to treatment and do really well, down the road, maybe I'll suspend some of that. But for now, I don't see any reason to deviate from that because you refuse to take any tests.
Okay.
So I'm giving you a $1,000 fine because of that.
Okay.
Your license is going to be suspended for 6 months. I'll give you 60 days in jail and suspend 50, give you credit for 2 days you've already served. So you got 8 more days of jail to do.
Okay.
I'll order that you do 30 hours of community service, serve 2 years of probation. I'm supposed to make you go to the driver intervention program, which is a 3-day program. And I'll put that in order, but I'll say will be suspended if you complete inpatient. So I'm not going to make you go to that 3-day program if you complete an inpatient program. So I'm going to order you to inpatient with Southern Hope after your jail time.
Okay.
And let's set it for a review. November 1st. Your first review hearing is going to be November 1st.
Okay.
At 9 a.m.
November 1st.
Yeah. Michael's here. Yes, sir.
Okay.
You have a question, Michael?
Yes, sir. So that will be, he'll be released around the 1st?
Yeah, let's see. He's got 2 days in now. No, the 3rd.
3rd, okay. Thank you, Ron.
He should be finished around the 3rd of October.
Okay.
So that was on the A case. What else we got? B and C. We got the B is the safety belt. Failure to control. Okay. $50 fine, failure to control. Child safety restraint, that's a mandatory $100 fine. Then he's got that old case we need to clean up. Okay, endangering children, yeah, I forgot about that, we've got to send something on the endangering children. On each one, I'll do a $100 fine.
Cost?
No. There's only one court cost per incident, so, all right, put it on the OBI. It's a $100 fine, 30 days in jail suspended on each one. So you've got a total of 120 days in jail suspended over your head if you mess up, that I could give you.
Okay.
Been on 17,866, we need to, yeah. We'll just recall the warrant and set it for the same date. You still have that old case you gotta take care of on it. You owe $285 in fines and court costs and 2 days of community service. It's set for November 1st also, for review. 9 a.m. Okay, that's all.
State of Ohio versus Brandon Spencer at the Lawrence County Jail, case number CRB 24535, CRB 13488, TRC 12570, TRD 101147, A and B.
It's Mr. Holt's case. Brandon Spencer.
Your Honor, I believe he's being held on an APA order. I've been in contact with the APA agents that have supervised Mr. Spencer, and even though he was terminated, discharged from the prior treatment facility he was at, they are recommending and asking the court to place him with another treatment facility. And they would release the holder upon getting notification from the court.
Okay. Was he at Southern Hope and was suspended from there?
Yes, Your Honor.
Okay, so we have any other?
Riverside is another.
I think that and they contacted me about it too, that they were going to find a place for him. So I don't know whether, let me read mine. It's okay, either way is okay with us, just want to make sure that. Now, in order for us to be able to agree to that, what we would suggest that he would go ahead and enter a plea to this charge and just give him credit for time served.
And have that as part of the sentence?
Yes.
But that was all in the case.
What was that?
There's 3 or 4 pending cases.
They're all old stuff. I think, I don't know if there's, I don't know if they could proceed. There was a criminal damaging that was never resolved. Physical harm to a mobile home belonging to Randall Ferguson. That's one case. There's an OVI. He was sentenced on that. The only thing outstanding is community service. He paid his fines. And then there was another traffic matter. It looks like it's completed. There was a driving under suspension. It looks like it was completed. So, an OVI and a criminal damaging, which was still pending.
And then this aggravated innocent.
Yes.
Is there 20 hours community service on OVI now? Is that what was remaining?
30. 42. It must have been a second because he had 60 hours community service. He did 18. 42 left.
There's a criminal damaging too.
From 2013. That was never resolved.
From 2013.
How do you want to proceed? Do you want to look at that, or do you?
You know,
there is a named party that supposedly had damage to a mobile home.
I guess we're going to need to figure it out, although it's been 11 years ago. Let's see if we can get the file.
Okay. You want a case number?
Well, Jasmine's already left the room. It was
Okay.
a 13 case?
13488. Okay, so Mr. Spencer, we got some things to research on your case. Prosecutor's going to do that. We'll come back after they get their information pulled.
Sir.
Okay, that's the only thing we had left at the jail. So we'll come back to you later, Mr.
State of Ohio versus Sierra Massey, case number CRB 24467.
There's a cross file on Mr. Stiers, the attorney on it.
What's the name?
That is Donzie Goodson.
Goodson.
State of Ohio versus Don Z. Goodson, case number CRB 24468.
What's the story on the bigger trailer?
We've already emptied it, ready to move it, or we've already contacted one guy about moving it. He hasn't come back to us. But we've decided you can't get nobody moving. I've already got guys standing by to tear it down if we have to.
Okay. Okay, so when we were here last, Your Honor, there was some discussion amongst the parties about a house trailer and a little, like just a pull-behind trailer for a car, like you put on a car or a truck to carry stuff. That's been moved. He has emptied out the house trailer. He has called somebody about getting it moved. They haven't contacted him back. He's going to try to give them a little bit of a chance to get somebody back, and if not, he has somebody that can tear it down and haul the parts away. So we're getting progress toward getting all the stuff off the property that the other side wants off the property. I don't know where that leaves us in terms of what we want to do going forward.
That part's satisfactory. I believe there's also a pull-behind camper that's just in between the two property lines that needs moved that's actually on her property.
Do you care to move that?
I don't know what you mean.
It's next to his house.
Right next to what you mean.
He says there's a pull-behind camper that's over under their property, and she's been moved over to yours.
Nothing like that on that.
I can show you a picture.
He's denying that that's on his property. Or, well, I guess they're saying it's on their property, not his, is the issue.
It's his house. And there she's saying the property line is on this other side, so it's 7 feet.
So here's the picture, and they're saying that this is onto their side and needs to be moved.
No, sir, it isn't. It's on the inside of my fence.
It does appear to be on the inside of the fence, but that doesn't necessarily correspond to the property line. I don't know. That may be, I don't know.
The house actually is over the property line, obviously, so you don't expect that to be.
Apparently the house itself is over the property line, but obviously there's no expectation that the house itself be moved, but anything outside the house is on, they're saying is on their property.
That's not true.
Well, you may have to hire a surveyor about that issue. That may be something they have to deal with civilly. I don't know. I mean, basically, it sounds like there's a dispute between the two of them where their property line lies. But the stuff that was definite, that was unquestionably, that everyone agreed was on the wrong side, has been moved.
Has there been a recent survey? Because she acts like she knows where the property line is.
Well, they pulled up, looked like.
I have the auditor's page.
The auditor's page, but that may or may not be accurate.
Yeah, those are not that accurate.
And also it was surveyed when he bought the property.
When was that, though?
Oh, I'm sorry.
Did you get a survey when you bought the property?
Your Honor, the surveyor, ma'am,
Talk to the lawyer.
I'm
He asked you a
sorry,
question.
the surveyor was called while I was in Beckley.
Was the survey done, though?
No, the surveyor came to my house to survey my land while I was gone, and he surveyed my land, and he, for some reason, Darren A. Gorby and John Gorby agreed to move my boundary line while I was gone and I wasn't around the surveyor. We talked to the surveyor about it, but he ain't got back to me yet. But he gave me, I went down to the courthouse and got my deed, and my deed shows everything I have.
But this sounds beyond my expertise on issues of property line boundaries. That's just not an area of law I practice.
Well, it sounds like that's to ultimately get this thing resolved, we're gonna have to have some agreement as to where the property line is. And it sounds like he had a survey, but he didn't like where the surveyor put the property line.
Possibly. But is it possible for you to move that trailer just to the other side of your house?
Yeah.
No.
Yeah, no place you can put it,
Can't-
we get this,
Apparently can't be moved, Your Honor.
then we can get the criminal matter over and then let them
Right.
dispute over where the property line is.
Yeah.
If you wanna do that.
If that's all that's holding things up, I would ask that if there's a property dispute, they might want to deal with that civilly. If this thing is as close to the house as it appears to be, and it's within a fence, I can't imagine it's actually causing them a problem. So maybe we could just leave that issue aside, and then if you end up getting something saying that the property line is over there, then you can, as part of that civil suit, ask that the trailer be moved. But at this point, so if there's a fence between the trailer and their property, which it appears to be, whichever side it's on, it's not hurting anything right now, would be my take on it,
And
so.
how long's the fence been there? That's another, gonna be another.
Well, I don't know that.
Yeah, less than a year, I think that's a big.
Okay, I didn't know it was a new
I think that's
fence.
a large source of issue.
Okay.
But again, maybe that's something that can be dealt with civilly, because I mean, we're not gonna adjudicate the property line here in criminal court.
It is a trespassing charge.
It's not a trespassing charge based on the presence of the trailer, though. I mean, I guess they could file an eviction if they wanted to. I don't know. I mean,
Well, is there some way of resolving this?
well, basically, he's the victim of her charge, she's the victim of his. And we're either gonna come to a resolution or we're gonna have a trial. I mean, they're either gonna agree to drop the charge against one another, which doesn't answer the questions of the property. That's something that have to be either agreed to or dealt with in civil court, or we have a trial on whether, he was over there and whether she shot at him. I mean, I just don't know the answer beyond that, Your Honor.
Well, I don't either, so you're gonna have to tell me, do you want a trial or do you want to agree to some sort of mutual dismissal? if that's
And then you guys can figure out the property line
And then if-
separately.
We're interested in resolving it, Your Honor, given the source.
Well, I understand that, but that's a separate case.
There's
That's
a
a
house
separate
trailer on the property that's his. I think that's undisputed. He's saying that he can't find anyone to move it, but he can find someone, potentially, if he can't find someone to move it, which he has at this point, he can find someone to tear it down and remove it off my client's property. There also is an older pull-behind camper that's in between a fence that's on her property that she says that she's claiming that the cross defendant had built in the past year. I think that's a source of the whole reason we're here. But she's just asking, and a discussion we had, she said, he's not going to be able to remove the fence. It's like I guess a kind of fully built cattle fence.
It's a wooden fence.
Yeah. She's not expecting him to do that, but she would like the camper moved, since it's something that he could easily remove.
That's not become the property line if you leave it there long enough.
Yeah.
You understand, I mean,
I believe they have horses on their side.
I do have horses on the other side.
okay, there's adverse possession in Ohio, 21 years, so if he put the fence, he's the one who put the fence there, right? So if you let it sit there for 21 years, that's going to become the property line. I don't know how much property are we talking about between where you think the line should be and where the fence is?
It's like 12 feet.
Oh, well, that's significant. So,
We shared a picture with them of.
Yeah, I mean, it basically just comes down to a question of whether they agree on where the property line is, which doesn't sound like they do. But that issue, even if we work out getting things moved and set aside, we're not going to be able to adjudicate the property line issue here anyway. So I would just suggest severing those and let them go and deal with that.
if we could agree where the property line was, that would probably resolve things.
Well, I think his position is that the fence is the property line, and their position is that his living room is the property line. Because they said that they believe the property goes into, that the house straddles the property line.
Well, he did the only survey though recently, right? But he didn't like it.
When it was purchased, I believe. Do you know when that was?
That would be something fine. Are there surveyor stakes still there, or were they removed?
I don't think the stakes are still there.
Somebody's gonna have to spring for another survey, sounds like. Those are not cheap, folks.
So there's no way to move the objectionable items.
Well, one he's working on, one he's saying it's on my property anyway. That's the issue. One objectionable item, he says, yep, that's on your property. I'm either gonna get it moved or I'm gonna get it torn down.
And one has been removed.
And there was another little pull behind trailer that's been moved. There's a third trailer, I didn't know about that till today, that's sitting, according to this picture, pretty much flush up against the wall of his house. and on the other side, almost flush up against a fence. He's saying, I own to the fence, they're saying, no, we own past your house. And that's the dispute.
Well, they're not,
So actually where he lives.
they're not
Yeah.
asking him to move his house.
Right.
That's something that they're.
But the house is, they're saying that the house overhangs the property line. He's saying, no, it doesn't, the property line's 10 feet past that, or whatever past that.
And I do a great deal of property work. What I think is probably that people relied on the auditor's site, which is not exact. But I would say, most likely with how just the form and everything takes, again, I haven't done a survey, it's probably 2 or 3 feet off his house is probably the property line, I would say. Now, they've relied on the auditor's site, but that's probably what I think's happened.
Can both parties agree to what can be moved to settle this situation here in this court? In other words, it might not settle everything.
Yes.
You might still need to do something civilly, but at least we could resolve it here.
That's our understanding, what we would like to do to resolve it, which one of the three, let me respond, please.
Go ahead.
One of the three, the easiest thing was a small, like maybe four-wheeler or lawnmower type pull-behind trailer. That's been moved, it's on wheels. I don't know the condition of the camper, that's the one that's at issue. But my client's accepting Mr. Steyer's client's proposal of giving him, I guess, come back in maybe a month or so and either have the mobile home moved or torn down and he having the whatever's left over removed from their property. They're satisfied with that point.
And then there's a pull-behind camper
That's
that
he
doesn't want to move, but does he have a place he could move it to?
I wasn't even aware of that until today. That we talked about the other two trailers last time. We didn't talk about this camper. He's saying he doesn't even know where to put it. I don't know if that's accurate. I don't know if given a month to figure the other things out, he might find a place to put it. So if we're planning on coming back in another month anyway, maybe he can figure out a different place to put it, or he can come in here and say, well, I've hired another surveyor, let's figure it out. I don't know.
My client will explore talking to a surveyor or get a exact understanding of where the property. Yeah, that's recorded, we can look at that now, but if you want to talk to a surveyor, even if they might have to resurvey, you can have them come out and just pay them for an hour or something, they can put a stake.
You could just do that one line.
Yeah.
So it shouldn't cost as much
Yeah.
as to do the whole.
I'll have to contact the surveyor.
Let's do that and we'll come back.
So I'd suggest we come back about a month out, Your Honor.
Okay. 21st, 25th, 28th.
21st, I have a jury trial. 25th and 28th, I'm available.
Can we do the 18th?
18th, I'm available.
18th better for you, Mr. Hall?
Yes, Your Honor.
Okay, October the 18th. For pre-trials.
Thank you, Your Honor.
You're welcome.
Okay, so see what you can figure out about the house trailer in the meantime. And if you can find somewhere to put that other trailer, put it there, but if you can't, we'll deal with it. But you should try to see if you can figure out somewhere else to put it.
All right, thank you.
State of Ohio versus Kimberly Miller, case number CRB 2587.
Sorry, man. Here, let me get around.
Mr. Holt's case.
Yes, Your Honor, this was called last week, but Ms. Miller was late. I believe the court contacted Mr. Sowers, and she did show that day, and you set it for today. Your Honor, I think this is an older matter that I think we have resolved. Mr. Hill made an offer to dismiss the charges if Ms. Miller would pay court costs, which she can today. I believe, unless there's warrant fees, I think it'd be $135, and to do 30 hours of community service, which she's agreeable with. That's Josh is the guy who does it.
So she's going to do that before we dismiss it, or?
Yes, I'm fine with that.
All right. And how much time does she need to get that done?
She's going to pay the court costs today.
I'll pay that
And then how
today.
long would you need to do this?
I can do that this week or whenever.
Can we come back on the 18th?
Yes.
Write that down. You need to-
Next hearing is October 18th. There's 2 double days coming up, the 5th and 12th.
You can get double credit for October 5th and October 12th.
Those are Saturdays. You get double credit those days.
State of Ohio versus Jacob R. Nichols, case number TRC 241236.
Which, is it, she okay to pay the court costs today?
Yes.
Okay.
See the clerk.
Turn one.
Mr. Holt's case, pre-trial.
Oh, yeah.
What can we do on this case?
Your Honor, Mr. Holt filed a motion some time ago that I anticipated he was going to file, but I never saw it. I don't know. It didn't get in my file. He wants to have an independent assessment of the urine sample, which he's entitled to by law. And my last conversation with him before today was just let me know what I need to do in order to facilitate that. And I guess, I don't know, nothing happened in between the last time and now. So I'm still not opposed to it. Obviously, it's his right. So the question
You want to
is...
submit an agreed entry?
I can, yes, Your Honor. I filed it on August 26th. I can't, there's no harm, no foul. We're fine with that, Your Honor, but there's going to we can do the entry, and then there's going to be some kind of communication as far as the state to inform me. The issue is it's an extremely, extremely small amount. So I'm wondering if the lab will even say it can be retested. That's the point of this.
Okay. Now, do you get to pick the testing lab?
I'm fine with
or how's that
agreeing.
work?
They have to be licensed. Obviously, we'd want to use somebody local, and because Mr. Nichols is liable for the cost of it. So I'm okay with agreeing if the state and...
You have a facility you want to use?
I would assume LabCorp here over in West Virginia would be, but I assume they would satisfy the Ohio standards because from past experience with ODIs, West Virginia standards as far as blood and urine are not up to, they're below Ohio standards. So if not, I think it'd probably have to be, Portsmouth would be the closest thing. I don't think there's one in Ironton, but LabCorp's national, so I assume they would meet it. And they're
Okay,
not.
so you want to investigate that, you guys submit an entry, and then we'll just, want to set it again for the 18th? And
Yes.
have that done before then?
And I'll draft the order before we leave. I just need to know if Mr. Hill can get in contact with the state lab. Obviously, I don't have the ability to authorize that, so, but I'll get the...
Yes, we can do that.
Okay.
In fact, maybe I'll do not only that, but I'll make sure you have their contact information.
Yes, thank you. You might want to check with them to see if it could even be retested. I want to ask if it could even be retested.
Well, we could do that, or they may have a recommendation. on that.
We're fine with that. We're fine.
Okay. Let's talk about that before.
Good deal. I'll redo the entry, Your Honor.
Thank you. October the 18th will be the next.
Thank you.
State of Ohio recalls Brandon Spencer at the Lawrence County Jail.
Oh, okay. So you want to dismiss that one case? then?
We'll nolly it with the right to refile.
There's no objection.
And we'll have more information from the parole authority about what they would like to see.
Okay.
I have a text from Mr. Stoneback. He
I've got 2 texts from him.
Oh,
so-
you were, I was going to share what he said.
We
He
need
said,
Mr. Spencer, we want Mr. Spencer in on this?
So-
State of Ohio versus Christopher Meade here at the court, case number CRA 24-122, CRB 24-123. That's Mr. Steyer's case.
Mr. Spencer will be with you momentarily.
Thank you.
It's a good report.
Make sure you can read my handwriting. That's my telephone. Just text me later, say it's Christopher Meade. That way you can go. Thank you. Well, Your Honor, looks like we have a good report. I'm not sure what sort of a time frame we're looking at on this. I think this was our first time back. I don't think our second time back. So I don't know, we're looking like a month or about 6 weeks or even 2 months.
6 weeks would be good.
Okay, 6 weeks, we can put us into early November. I have a jury trial currently on the 4th, but I'm here I'm available the 1st and the 8th. The 12th, the 11th is Veterans Day, so I assume we're closed that day.
We are. Let's do the 8th, November 8th.
Okay, he's writing that down.
Your Honor, this is something that I just realized that the alleged victim in this matter is Courtney Corbin, and she is
Yeah,
a
we just
defendant.
arraigned today.
Yeah, so we've got a cross-filing situation. She comes back to court on October the 11th, so I don't know whether it's best to have them together at this point.
Honestly, that probably makes the most sense, so at least to start with. So let's go ahead and maybe I'm available the 11th, we can jump back to the 11th if that's a workable day.
All right, October 11th will be the next pretrial.
I knew that I didn't realize it was a cross-file, so I apologize for that.
Well, it didn't happen on the same day.
Oh, okay, so it's just 2 separate incidents with each, okay, I see what's happening.
She's the mother of at least one child of his.
Okay.
I understand it.
All right, so we'll come back to the 11th. Okay. Keep up the good work, man. Sure. You got my number.
Okay, Brandon Spencer is on the screen at the jail on 13-488. The state's going to choose to nolly that. So that leaves us with 24/5/35, there was an old OVI that there's just community service owed on. And then there was a traffic matter that was completed, that other case that was with it. Just don't even worry about it, it's done.
Your Honor, I think that the state is going to motion to dismiss the 13 case with the right to refile, or to nolly with the right to refile if necessary.
Yes.
And then we would ask that the menacing is currently pending, and if the court deems proper, consider the OBI satisfied, because he has spent some significant time in jail on this.
We're okay with that.
Okay, so 12/5/70 will be ordered completed, community service, and everything is considered completed, so no further obligations on that. Completed by jail time.
There's a CRA. Do you want me to check the preliminary?
I believe the
So that just leaves us with 24/5/35.
Yes, and his AP agents, before we did it, they did not feel that it was, the violation gave cause to send him back to prison, so they wanted to send him to another treatment facility and ask the court to make that a term of the court's probation as well, whatever you decide for Mr. Spencer's term of probation to be, Your Honor. And pretty much tell us the message from the APA was if he gets a successful discharge from this, then they likely would ask to send him to prison if he doesn't complete your term of probation.
Okay.
And in
Does anyone
addition-
have a bed for Mr. Smith? Is the state on board with that?
Yes, and the parole authority is okay with the court determining which program he's going to go to. So I wanted to say something.
Yes, we're fine with that.
Okay. I just needed to
Okay,
say something.
sorry.
Okay. I don't see anybody raising their hands.
He has a previous charge that prevents about 98% of us from taking him.
Okay. We got anybody here in the 2%?
I mean, fine, Bree.
I guess, Your Honor, we can, so the mechanics of this wouldn't be, I assume he would
And
get
how many days?
We can do his assessment, we might be able to get him later though.
Okay.
What's his name?
Brandon Spencer.
I'll have him to do his assessment, it just probably won't be today though.
Okay. I'll put it back on the docket for Friday, and you can appear by telephone.
Okay.
Thank you.
Okay, Mr. Spencer, looks like OVP is going to be where you're going to go. They don't have a bed available, but they're going to assess you, and then if they agree to accept you, I'll go ahead and enter an order that you can be released to them. But just to make sure we don't lose you, I'm going to put you back on the docket for Friday, 27th, for a pre-trial.
So is that for a sentencing, or do you want a sentencing?
We can do it as sentencing, or on the docket or something. We want to go ahead then and just do the sentencing. Makes sense to do that. Order and release to ODP, and they can get him whenever they can.
Okay. Understood.
Okay, so on 24/5/35, $50 fine. Court costs. Was there an agreement on how much jail time to be suspended?
There wasn't, Your Honor.
There wasn't, but we'd say, I mean, I don't know how many days he's been in jail.
I'm sure he knows.
He was booked the 16th.
He got a prior, he was in for, I think, a couple of weeks prior to that.
15 days. And I think it was 24, 25 days, probably, somewhere around there, 23 or 24.
Your Honor,
15 days after rehab.
So if we would suspend, give him 90 days suspended and give him credit for the time he's incarcerated.
State's agreeable.
That's fine.
90 days in jail. Suspense 66, credit for 24. Be ordered released to OBP whenever
You may have to keep him in an extra day so they can do the eval.
yeah, let's put it, let's, on the suspension, let's do, let's get it to Friday, so make it suspended 62. But he can be released to OBP whenever a bed is available. And I'll put it on the docket for Friday just to make sure he's not stuck there in the jail with nothing happening.
I'm here.
You should be at OBP by Friday, I would take it, so.
I gotta get out of work, man. What?
Okay, forget it. It's off. You can stay in jail. See you Friday. Set it for trial.
Fucking got a kid and shit. Put it for trial.
Okay, you're held in contempt. I'm adding 15 days to jail, whatever you get. Okay, he's not on for Friday. Let's go 15 days out before he even comes back.
I'm not available here for this.
Okay, set it for the 18th. Next hearing is the 18th. And just set it for a trial on the 18th at noon. That's a guy that doesn't understand. He doesn't have any cards. I mean, if he messes up, he's going back to prison. He's got more to worry about than a few days in the county jail. Okay, we're down to the jail. I think we need to just take everything off. He's not getting released to anybody. So, no assessment needs to be done on him.
So he'll just be sentenced to 90 days and we'll deal with all, well, against life for trial. So-
I said for trial, I'm not even going to do that deal.
So now he's on, still on the holder for APA. I'll call
Yeah.
APA.
State of Ohio versus Richard M. Nance, case number CRB 24-151, TRC 19-3086.
I know the letter's kind of hard to read, but he is compliant.
Thank you for that report.
We've been at this one for about 6 months at this point, Your Honor. I'm not sure what sort of a timeline the state and court are looking for. Now, there remained also an old case that had a community service balance and a small case balance. I'm not sure if anything's been done on those.
It should be updated. It's been done.
I need a community
He's got-
service.
I'm showing 14 hours community service and $50 left on the old one.
Okay, so I had 54 hours community service, so it's definitely been updated since what I had. He's reporting, he thinks he's completed those 14 hours, but that's not, you think you're up to date?
I would say so. I don't have proof of the 14 hours.
Do you know where you did them?
Any
mission, community center?
That's where he was doing, and that's what that was reported.
Okay. So you still have $50, which you can do, a one-day community service will wipe that out, right? Am I correct?
$50, yes. But he has to do the.
But you also have the other 14, you either need to get the proof that you've done them into here, or you need to go ahead and do them, one or the other. So, I would assume that we want to set this out again one more time and maybe see where we get on the older matter as well.
Is the new one to be, is that a dismissal of domestic violence? Josie Nance is the complaining party. This looks like the family member.
That is correct, Your Honor, and yeah, that was our intent eventually to, as long as there weren't any problems, and as long as he completed his, or at least made progress in his counseling with OVP.
Yeah, he's doing great with his counseling.
Okay.
So again, I mean, I don't know if
No
we're
downside to keep going then, I don't guess.
No, not really. Just keep it moving, and maybe when we finish this old case up, that might also spur the state to look a little more kindly toward a dismissal on the new one.
Let's come back the 1st of November sometime.
You can give me just a second, I'll pull up my calendar. I do have a jury trial somewhere in there. I have a jury trial the 4th.
Could do the 1st.
I'm available the 1st.
November 1st will be the next hearing.
Thank you, Your Honor.
Thank you.
You might want to meet with him on the non-court day and talk to him and get figured out what the situation with those hours is, okay?
State of Ohio versus Melissa Graham, case number CRB 24-462, CRA 24-513.
You've already done it, I would.
Okay, let's leave it alone.
But the levels are going down.
Yes. It's a very good report.
Thank you.
Back in another month, Mr. Morford.
I would say that's good, Judge.
$18th or 21st?
I think that's good.
21st, October 21st.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
State of Ohio versus Hunter Tooley, case number CRB 24385 A and B, CRB 24329, CRA 24328, CRB 24292, CRB 23447.
Mr. Morford's case, Mr. Tooley is at hometown. Okay, it says you're going, making progress and moving in the right direction, so that's all good. Grandma, how do you feel about that? Good? Good.
Thank you.
All right, so he's going to graduate in February, so we got a ways to go. Keep checking on him for a while. How about October 28th is the next one.
That,
28th of
well,
October.
that's good, Judge.
A little over a month. Okay, good job, good start.
Thank you, Your Honor.
Thank you.
State of Ohio versus Travis L. Black, case number CRB 23743.
May I have Brett?
Yes.
Where did they have four? And Rob Evans. Where did they have four?
It's a good report, but it kind of makes it sound like there's still stuff being worked on.
There is.
Okay. And we went 2 months this last time. Is that still appropriate? A couple months?
Yes.
November 25th, that's the Monday before Thanksgiving.
That's good, good, Judge.
November 25th will be the next one.
Thank you, Your Honor.
Good job, Mr. Moore.
Sir, thank you.
State of Ohio versus Brian Crawford, case number CRB 24330.
This is Mr. Stratton's case.
Yes, Your Honor. We are going to plead guilty today to the charge. I understand that you would want him to test, so I'll go do that and then come back.
All right, have Mr. Crawford screen, and then I'll do the sentencing.
All right, you go with him, go with Josh. You pled guilty like we had talked about. And now you gotta go take a test. Huh? Yeah, but you have to go get tested first.
It's the Robert Tate Roach of Thanksgiving. That's what it is. Your son or two.
State of Ohio versus John W. Nunley, case number CRB 24471.
This is set as a pretrial now.
Yes, Your Honor.
We got all kinds of witnesses too. What time is it?
It's a trial. It's pre-trial.
Oh, that's right.
Yeah.
3 days suspended, no contact.
You want to address that here? Just 1 second. Somebody wants to go. So it was for trial today. It's actually just a pre-trial. That's what it says.
Hey, Sean.
Yeah.
What do you? See what No, I don't think so. They're also concerned with these guys. And they're scared of it.
Your Honor, I don't think we have a resolution of this, or we can reset the trial date on this.
Do you have a preference?
Just not next week.
Does the state have any preference as to trial date?
Well, Your Honor, I believe we have to ask Ms. Sword what her feelings are on the matter, but we don't have any particular problem with any date, except for maybe if you have a complication being here on another day. So whatever the court decides.
Well, the 15th is going to be a kind of small docket because it's an off day, but I don't know if you're going to be available then, Mr. Stratton. That's Tuesday.
Yes, Your Honor, I will be available that day. It'll be a good day. Yeah.
Okay, noon on October 15th for trial.
October 15th.
All right, so we're going to get new subpoenas.
Yes.
State of Ohio versus Virginia M. Malone, case number CRA 24498, A and B.
Can I approach your Honor?
Yes.
Okay.
Yeah, but I just. Let's put those over there.
It's an accomplishment, for you should be proud of it.
She want that disconnected.
report?
Yes. Yep. Very good.
Continue on, monitoring.
Yes, Your Honor.
Sometime around the 1st of November, 1st, 4th, 8th, any of those were
Yeah, whichever day is fine with the court.
November 4th.
November.
Your Honor. State of Ohio versus Scott Taylor, case number TRC 24-1941.
Judge, we're going to have a short continuance. We've gotten the written response to discovery, but we don't have the link to the video.
October 7th.
Good here, Judge.
October 7th will be the next pretrial.
You got it? Okay, I'll see you tomorrow. No driving. Thank you, Your Honor.
State of Ohio versus Charles Booth, case number CRA 23-145.
Morpheus case, preliminary hearing.
That's Chesapeake Village to release my license and get them.
I have a letter and call from Marshall Health
Yep.
dated September 17th.
Last time, if I could speak to you, sir. Last time I was on a video visit last week because I was on the boat. I actually went ahead and signed a paper for the court and Morford, so you all could all have access to it, and they're going to file, well, send weekly reports to you all too.
Okay, very good.
This is the only court I have left. Everything else is paid off. So do you?
What's the state going to do on this?
We're not opposed to him continuing in his treatment.
Do you have your schedule, work schedule?
I leave Thursday. I'm gone for 3 weeks, so I'll be back 3 Thursdays from this Thursday.
Okay. So you'll be back on the 17th, so this Thursday's the 26th, and one is the 3rd of October, 2 is the 10th, the third one will be the 17th, so sometime after the 17th, you'll
Yeah.
be back. How long are you in before you go back out?
I'm usually in, my schedule right now is 21 and 21.
Okay. So I'm gonna give you, because that's when you go in for your treatment, right, when you're in.
Yeah. Like, I'm pretty sure, I got, let's see, my next treatment date is
How about November 1st? That should be, you would have been in for a couple of weeks by then.
Yeah, that's fine.
I'm good then, Judge.
Okay, November 1st will be the next hearing.
All right, thank you, sir.
You're welcome.
There you go. You're on top of it, ain't you?
Thank you, Your Honor.
State of Ohio versus Cameron J. Cox, case number CRA 24532.
Mr. Steyer's case, preliminary hearing.
Your Honor, I was just appointed to this case this morning. I've familiarized myself with the documents that are in the court's file, talked to my client a little bit. Appears there might be some issues on this case that we need to flesh out, and even though the charge is one that's rather serious, the state has agreed to keep it here at least for the time being. Now, there's, to be clear for the record and for my client, to make it clear to him, there's not a guarantee that this one will eventually go on to the grand jury, but that at least in the short term, the state's willing to keep the matter here. We're willing to waive time constraints to accommodate that. So I don't know how long the state wants to take to look at the issues, but we're on board for whatever they have in mind. And I guess the victim's here. There's no E. Okay.
So you don't even think he went in the house?
No.
Why did you tell him that he did? This is the one I've got right now.
He's already here once. Let me go. Let me look at my notes. His name spells so weird. So, okay. This is her ex. That's who she was seen at the time when they were separated. He's already been arraigned. And his case is not went to the grand jury. Yeah. But she knows that.
Okay. Okay. Your Honor, it's a kind of a complicated fact pattern and involves a number of names that we're familiar with in Ironton Municipal Court and in Common Police Court. Wanted to make sure that I knew exactly where things stand. Now, this is Ms., what's your name, I'm sorry? Ms. Duncan, and she's the homeowner at the place where this happened. She says that Cameron Cox did not go in her house without permission. But there's another fellow by the name of Stetson Gibson who his case came through here recently on 9/13 and was nollied to the grand jury. So that case is headed there. So I think under the circumstances, since Ms. Duncan says that he's not guilty here, that we just go ahead and nollie this charge.
No objection, Your Honor.
Case will be nollied.
Okay, so it was dismissed.
Thank you.
You're welcome.
State of Ohio versus Bobby J. Ferris, case number CRA 24282.
Mr. Stiers' case. The report says he's doing well, but he has some appointments and he needs to stop missing them, and when he does, he needs to reschedule them. It's not.
That's what I was just explaining to him. Other than that, he is doing well. He is coming later to his appointments and he's remained compliant, but if he can just reschedule them instead of miss them, that's the only issue he's having.
I missed one, and it's rescheduled.
Mr. Hill?
Well, if they want to continue providing him treatment, then we don't oppose that.
Okay. November 25th?
November 25th?
Yes.
I'm available.
State of Ohio versus Billy E. McKenzie, case number CRA 24497, A and B.
Mayor hearings, Mr. Stiers.
Maybe out of
And is that TCC?
There's something else wrong.
Oh, it's 2 pages, okay. I have 2 copies there for a second. And Your Honor, I believe there was originally an A case on this, 24 CR 497A, which my understanding has already been nollied, and we're still continuing on with the CRA 24497B, which remains pending.
Yes, the A case was not.
I'm sorry. Yeah, that's what that meant. That's what that meant.
Sorry about that.
No, it's okay. We throw around our own language, and sometimes you guys don't understand what we're saying, so we need to slow down and make sure lawyers can make anything confusing. That's our one superpower. So, Your Honor, I think we've got a pretty good report here on this matter. I would ask the state what its pleasure is on this, and the court, obviously.
I'm still on the last case. Who is this?
Okay, this is Billy McKenzie. You've got right over here the report, which is positive.
Well, then that's good.
Billy's doing extremely well.
And he stayed after he had his ankle monitor.
He did.
Yeah.
It's always a good sign.
Oh, that's hard. All right, so this is just a possession charge?
Yeah, the possession charge will remain.
All right, and this is his thing here.
Yes.
And he's doing well?
Doing extremely well.
Has he reached the conclusion point?
Not yet.
Pardon?
Not yet.
Okay.
So he's at 2.5. You have sort of a projection on how long that'll take? Not necessarily down to the day or anything, but just...
Maybe month and a half tops.
So 4 or 5 weeks seems like a good time to come back and just reassess where things are.
November 1st.
That would work for me, Your Honor.
November 1st will be the next time.
Thank you.
Thank you, Your Honor.
First, can you do this? Yeah.
State of Ohio versus Gary B. Thompson, case number CRA 24570, CRA 24533, CRB 24534, CRB 24553.
Mr. Thompson is represented by Mr. Stour, and he's at hometown.
And Your Honor, I spoke to, I need to close my other file, so I'll start putting things in the wrong one, I apologize. Spoke to Mr. Thompson earlier today. He reports that he is feeling very positive about what he's doing there. He's feeling like he's getting his life on track and it's been a good fit for him. Looking at this report, it look like they're kind of feeling the same way. So
Yeah, it says Mr. Thompson has been helpful in-house with other clients and brings a positive attitude and energy to the facility. So that's really good remark. So congratulations on doing that.
Thank you. So we're off to a good start on this. There's a lot of moving parts here. We need to, I talked to Mr. Thompson this morning about the fact that we're gonna need to continue on with this, and he's gonna need to continue to give us good reports. I said that before I saw that report. If you can continue to give us reports that good, that's gonna be very positive. So, this is our first time back since, arraignment, I believe. So I don't know what kind of a time frame. That's about 3 or 4 weeks. I assume you're going to keep on that same basic time frame this early in the game. So I just leave it to you when you'd like to come back.
Say around a month.
Today's the 23rd. 21st, I've got a jury trial, but the 25th I'm available.
How about the 28th?
The 28th I'm available.
25th is starting to fill up, so let's make it the 28th, October 28th. Be the next game. Really good start, Mr. Thompson.
Thank you. That's very good. Thank you.
One of the things, Your Honor, I would like to address briefly is that on the breaking and entering, I mean, we have some victims here. So this is not just about, we're encouraged by the treatment and the progress, but at the very least, on the breaking and entering charge, there is a restitution request being made of $789. So I realize when the person's in treatment, it limits them, but this has to be kept in mind. We've got a couple felonies here.
And Your Honor, as we move through this, obviously he'll reach a point into treatment, because assuming he continues to do well, he'll reach a point in treatment where he'll be able to seek employment. He actually believes he has the possibility of getting his old job back. So, and once that happens, obviously, one of the things we'll have to look at is getting that restitution together in order to keep things moving. So we recognize that as well, Your Honor.
Okay.
State of Ohio versus William Kaplan.
Thank you.
Case number CRB 111152. William Kaplan.
Good on everything? I think. Okay. If not, I'll burn
Set
it.
for sentencing today. Kaplan.
Hey, my problem, Phil.
I believe he's got a bond up now. Yes, he has a bond up.
So I need to explain this sentence.
So, contact Mr. Sowards and let him know if he not show up, and it's a $4,000 bond.
Your Honor, he's been at community service several times.
Well, for some reason, he didn't appear today, so.
Okay.
So, this guy is through common pleas. I don't know, it's a IOC.
So we need to set a bond forfeiture hearing.
Drug charge. So he gets that drainage.
Set it for October 21st.
They're in Mexico, so I don't know if we'll do this in Henderson, but he can get the exact thing from AEP. And if we can't order it, he just puts his son to get out of it if we can.
Well, we don't have to send this today.
Well, okay, that's what he originally told me. And he was here a few minutes ago, and I saw him in the hallway process.
It's going to be hard.
State of Ohio versus Michael Johnson. Case number CRB 24323.
Yes. He's never going to even get an exact figure from AEP. He's struggling. So he knows if we can't order it, we can't order it.
Okay, this is on the sentencing docket today.
He's in treatment.
And you're, are you at
No,
Hope
that's what he
Source?
said he's been doing.
Completed it.
You completed?
Yeah, Madison Adams was supposed to send over a copy. I see her later on today, I'm gonna have her do it.
To show what his prior bills were. See how it went from 75 to 352. It was over next meeting. He said, I'm not gonna give him the same thing. Just say, hey, he was this much larger. So I don't know. He says we can't work, we can't work, but as soon as he's got lost. But he's doing something already through common pleas.
He is.
Yeah.
Okay. Well, I have to take my glasses off to read.
Are you still been appearing in front of Judge Ballard? What's going on with that?
Yes, I report every week, every Monday to probation over there, Madison Adams. And I'm working, I got
Right now, I'm working at a house fixing floors. Not making money for it, getting a place to stay.
Does the state have the file on this? This was a theft of electricity from his father, so I don't know if there's any restitution.
He actually was here today, and he has a figure that he believes is an accurate amount of electricity that was actually stolen, and his figure is $900. So if he's willing to calculate to that figure today, then I guess we could we could go ahead and do the sentencing if the court was ready to do that today.
How do you feel about that, Mr. Johnson?
And what was he saying? I missed it with him.
He's saying that your father is saying that he thinks the electricity that you took was worth $900. That's a lot of electricity.
Yeah. Would there be a way for me to get copies of that and check it and then come back and...
I mean, we could have a hearing if you want. I'll set it for a hearing. You don't have to come in and testify as to how he figures up.
I just wanted to see which...
I'd kind of like to see it myself.
Well, what he has here are bills from before and then bills during the time. And so he looked at the excess of the bills over what would have been billed normally. So, I mean, this is the first time I've laid eyes on these. His father was here today. Now, I would also like to say
I talked to him too.
His father is encouraged and wants him to do well in treatment, so that's a big part of this.
Well, you would be eligible, or you are eligible for a court-appointed lawyer. I think he came in and pled guilty at the arraignment.
No contest is what I pled.
You want a lawyer to represent you on this issue of the restitution?
Yes.
Mr. Stratton, I'll appoint you.
Yes, sir.
Yeah.
I just want to make sure the figures are right.
Yes. Sounds like we need to set it for restitution hearing, Your Honor.
Right.
Sounds like the figures, there we have the figures. So we just need to get...
You got some documents you can produce for Mr. Stratton to look at? Or?
Yeah, I can give you what we've been given today. I don't know if there's any explanation along with that.
That might be a start, and then for more.
Yeah.
So what we'll do is we'll set up for restitution hearing. I'll get the copies today, Your Honor. I'll give you those copies today. We'll go from there.
When do you want to come back?
Whenever it's convenient for the court. Not next week, though.
15th or 18th of October? 15th is Tuesday.
15th is fine, Your Honor.
October 15th.
Yeah.
So restitution on sentencing.
October 15th. Okay, I'll call it down.
We'll get copies of that. Here, that's for you.
State of Ohio recalls Crystal McMillan, case number CRB 16688.
This is a review hearing today. It should be actually on the sentencing document, because there is a bond there. You still have community service.
Yeah. Yeah, I paid off my fine the other day, so I think I did, I think I've done a day. I just had a...
One in September 4th.
Yeah,
You've got 2 days coming up that are double credit days.
It's on Saturdays,
October
right?
5th and 12th. So you get 2 for 1. So that would knock, you owe 36 hours. If you do those both, you're going to get, you'll be down to what, 12 hours then left.
Okay.
All right, I'm going to put you on the sentencing docket because you do have a bond, which is where you should have been all along. So let's make it the 28th, October 28th.
what's that mean, the sentencing docket? I thought I was already sentenced for.
Well, you have been, but I always, when somebody doesn't appear and they have to post a bond, then I put it back in sentencing to remind me that you got a bond up.
Okay,
So you've got a bond up now with Mr. Soward, so he will come fetch you if you don't come to court.
right, okay.
Sentencing October 28th. Once you get this done, you can come to these hearings.
Okay.
You get it done before then, you don't have to be here.
All right, thank you.
You're welcome.
State of Ohio recalls Brian Crawford, case number CRB 24330.
I haven't written it down yet, I just got the sample, but it's going to be positive for cocaine, methamphetamine, fentanyl, and THC.
Okay. Well, obviously, we need to address that.
We do.
How does Mr. Crawford pay for medical service?
I had Medicaid,
You got Ohio Medicaid?
West Virginia.
West Virginia?
And I do have applications in, like,
Are you living in West Virginia?
yes, sir. After COVID and all that stuff, I tucked tail.
Well, you don't have to apologize. I lived in West Virginia. I was born in West Virginia, went to Ohio for a while, lived in West Virginia for a while, back and forth.
No, I like West Virginia.
I think
yeah,
it
like
just
that.
makes a difference on who can treat you.
Okay.
Your Honor, I think we should probably give outpatient a try and then
I'd say OVP.
OVP. Okay.
Now, he's testing for a lot of stuff, so I want to get it. All right, Brandon's still here, so I want you to talk to Mr. Riley and also see Mr. Major. He just did the screen. He can tell you what, one of the things he tested for was fentanyl. So we can't, they've got to be on a short leash here because if you're out in the community taking drugs that has fentanyl in them, you can die.
I understand that.
You understand that? It's very dangerous. So do you agree with me, if you can't get it under control on an outpatient basis, you will go to inpatient?
Yes, sir.
Okay, for your own safety.
Yes, sir. I know that for what it's worth, not, I don't figure it matters, but like, I heard someone say, thank God, I may not be where I want to be, but I'm not where I used to be, and I admit it's wrong, and there's things that people ought not do, and I never, you ever do things you never intended for the consequences, but like, I admit there are issues there, but like, for what it's worth, I'm not where I used to be on certain things, and I know that looks bad, and it doesn't give a whole hell of a daily life, but yes.
Okay. Well, we want to get you where you, because really, I mean, I don't know what you're referring to. We had a lot of heroin in our area at one point, and that's kind of gone away to a large extent. People aren't doing that. But fentanyl in some ways is as bad or worse than heroin because it's like
you're totally right.
Silently takes people. I think heroin has a worse reputation, but fentanyl probably kills more people than heroin did.
True.
Right. So, and it's out there in our community. The thing about fentanyl is it only takes a little bit of it. They put it on everything. There was a story on 60 Minutes last night about fentanyl, and that's one of the, it's a business model of the cartels that they want to put this on everything because they think it makes people more addicted. I mean, fentanyl is very addictive, and then you're going to come back and buy more stuff from it. That's the whole idea.
I threw out my back years ago working at Lowe's in a lumber yard and whatever, and yeah, instead of doing prayer or doctor or anything, yeah, someone would always try this out, and it was a very poor decision upon my part. And
well, that's the way, I mean, that's not uncommon. People got started on the opiates by an injury of some sort.
well, and I, not that, I don't know if it matters or not, but like, yeah, I'm beyond remorseful and ashamed of my own actions, even with what brings me, the reason I'm here in the first place, because I was in between jobs and stuff like that. I was just literally trying to get some necessities, and because I mean, I can pull up the Indeed app on my phone right now, and I can show you I've got like 70-some applications in, and as even when I reapplied at like fast food restaurants and stuff like that, because before COVID, I was a federal government contractor putting track and suspension on the Bradley armored vehicles with the U.S. military and stuff, like before COVID. Like I was doing really good, and then COVID, and kind of fell back into some old
Are you a
ways.
veteran at all?
No, actually, out of the 13 people I worked with, though, I was the only civilian, and I took it as a very high honor and was very happy and glad that they chose to bring me on the crew, because all the rest of them were, as they call themselves, ex-Army rats and Navy rats, and I was the only civilian that got hired on
That's one
full
thing we
time.
can try to help you with is maybe direct you to some places where you can get employment too, but we gotta get you clean from
Yes,
that
sir.
first.
So when would you like to come back, Your Honor? Would you
Couple
like?
weeks.
Couple weeks?
And you live in Osage?
Yes, sir.
Okay.
From my house to St. Mary's, about 14 miles one way, so.
Okay, what's OVP's closest location to that, 20th Street?
Yeah.
OVP's on 20th Street.
Nice Avenue. I know the
Or
building.
6th, that's not OVP.
Yeah, 6th
OVP
Avenue.
6th.
Okay.
That's proactive at 8th Avenue.
Oh, okay, I'm sorry. I see the places, I'm through there lately, yeah.
Before you leave, to talk to her.
Okay.
So you're up 14 miles and you're up almost to Newport then.
I'm right before the new Alcon plant up on Fraser's Lane, and stuff like Green Acres, yeah, I'm in that
You're up
vicinity
above
there.
Crown City on the opposite side of the river.
No, I'm actually right before Crown City, around Green Bottom and Green Acres. Because it's a journey to come and
You
see
can get
her.
into Huntington though to get some counseling?
I can get transportation for the time being, yes, sir.
All right, let's see. 7th of October.
Yes, here.
Okay, I'm going to see you back on the 7th.
Yes, sir.
And let's go ahead and just sentence him and then we'll make it a review. But you agree you'll go to inpatient if you're not doing well
Yes, sir.
by then. I'll get a report, they're going to tell me how you're doing. If you're doing okay, we'll keep you on outpatient. If you're not doing well,
Okay.
you're going to go inpatient.
I don't have any paperwork or anything. Like, can I get something on paper? Because my memory just like this, if I didn't have this, my
You're going to
memory.
get a judgment entry that says what you're required to do.
Okay, thank
So
you.
you're going to sentence him today, Your Honor?
Okay. Okay, I'm going to go ahead and do the sentencing
Okay.
today. Okay, I'm going to sentence you to a $100 fine, and I'll suspend 50 of it if you complete treatment.
Thank you.
Or you pay court costs,
Okay.
60 days in jail, and I'll suspend all of it if you complete treatment.
Okay, but that's, if I mess up, it's 60 days. Okay.
Right, I
God
can put
bless
you in jail for 2 months if you mess up.
Yeah, I
If
really
you don't mess
think
up,
that.
I don't want you to go to jail.
Yeah.
But I want you to have something over your head so you'll do what you're supposed to.
I appreciate it, and I thank you. I never dreamt.
And I don't know if, is this a relative of yours?
It's my mother. I tried to put
Ma'am,
a,
you need to understand. Fentanyl is in, listen, just listen. I'm trying to save his life. He's using illicit drugs off the street, and fentanyl is in everything, and it's killing people. Do you understand that? So we want to get him clean. You'd rather him be clean than in the cemetery, wouldn't you?
Yes, but.
Okay. So I'm giving him a suspended jail sentence.
yeah. Yeah, I'm not going to jail.
Suspended jail sentence. That means he doesn't have to go, as long as he does what he's supposed to.
Thank you, Your Honor. I appreciate it.
And he's going to first go to outpatient treatment and try that. If he doesn't succeed, then he'll go to inpatient treatment. It's that serious.
Thank you, Your Honor.
So he's going to talk to Brianna about getting that set up.
Yeah.
And we can put that in there. OVP for treatment. Start outpatient, inpatient if fails. First review hearing is October 7th at 9 o'clock.
2 years, level 5.
2 years, level 4 probation. Order to stay out of Walmart's.
I'm already been there
Can't
for
go to Walmart.
life. Yes, sir.
You can go to Lowe's, but you can't go to Walmart.
I'm not going to let it in.
All right. So
Thank you.
go over to probation and get signed up over there with John.
Go check him. You just got to talk to Brianna and Mr. May.
And then I'll do it.
Thank you, Carl. You're welcome.
I'll give you the correct action.
Court's adjourned.